favor. Wait for them to show them up. Yeah, I downloaded those documents today and I was going to share it. Eric, did you try audio? Helen, can you pronounce the case, please?
Yes, Judge. We're on the record in Gonzalez versus Velasquez Gonzalez, D18575-860D.
All right, thank you. So this is in your bar number, starting with the plaintiff first.
This is Nathan Gibbs, bar number 5965, appearing telephonically or by Bluejeans with Luba Gonzalez.
Is Luba in your office?
No, she's separate, Your Honor, but she's here.
Oh, she's under her, Philip David.
Philip, yeah, that's her.
Oh, there. Okay. And Mr. Gibbs, you're retained?
Yes.
And Ms. Lozano, your former counsel? Correct, Judge. Thank you. Your bar number? 3475, Your Honor. Okay, whose motion is it? I think what happened was the Discovery Commissioner couldn't fit this in an order shortening time, so passed it off to the district judge and sent it back to my department. February 19th, which after you said, please, we were going to set it for a hearing on May 1st. You said to have 30 days ahead of time any kind of problems with my bill, and that was supposed to be done by April 1st. We did receive something by August 14th, so we did get something. That hearing was continued from May 1st to June 1st, then rescheduled and then vacated and rescheduled to September 15th. So all I'm asking for, Judge, and if we need to share the documents, we can. We're ready for that. But we've already, they asked for, there were certain charges that they questioned. I've already removed those. There's a separate statement when they questioned the whole bill because they were trying to get around the charging lane by asking for a subpoena, which is a little later on. The state bar had a problem with that. So that's what we I'm going to argue Nathan Gibbs' motion for some request on discovery. I read the October, Judge. I read the opposition from Ms. Lozano, and Mr. Gibbs filed a reply. There are exhibits filed, your communications. This is an argument of law in terms of charging lien, retaining lien. This is some type of lien legal question. And I'm here to rule on that discovery matter, on lien issues, or any other substantive matters. Just procedurally speaking, I don't disagree with your procedural history, Ms. Lozano. It just, discovery couldn't hear it on a shortened time, and so it got passed off to me. And I put it back on my calendar. And it's one of those motions, it's one of those motions I had to read up a lot on the law, the Argentina case, the Leventhal case, the Fridanelli case. I'm up to date with everything, so I just want to know how persuasive either one of you could be on how the court should interpret the case law and how I should rule on what's going on with the discovery. But go ahead. So what we'll do is, give each of you about 10, 15, 20 minutes to argue, and then opposing counsel argues and did a 5-10 minute rebuttal, and then I'll roll. So that's simple. It's all briefed. I've read it. I went through all the case law and sort of have an idea here, but I want to know how both of you analyze your legal positions in this case. All right, let's proceed. Mr. Gibbs, thank you.
Okay, first of all,
One thing for procedure, Your Honor, is that we were noticed from your department that those motions were set on October 13th at 9 o'clock, and that today was only a status on the prior motions, not anything on these new motions. So from your department, we were told that the motions are set, and if you look at the calendar of the court, that is set on October 13th at 9 o'clock, Judge. I'm not disagreeing with you. Are those motions like a third renewed motion, etc.? Motions? They are, Judge. Are they totally related to this current motion we're going to argue today? Absolutely, Judge. If you want to do an issue of interest of judicial economy, we will stand on our opposition. And I do want to make sure it's clear for the record that we had no problems with them just deducting $4,265.90 from the bill so that the agreed amount would be $14,124.60. If you need the back and forth, you asked us to file that separately. If you need that from us, you can sure we'll file it. If you need that, we'll have their statements as well as ours. If you need those to back that up, Judge, but that's our position at this time.
Just noted. Duly noted. We will proceed. I think what Ms. Lozano was saying that because there's these motions set for October 13th, they feel that their opposition relates to the same matters we're arguing today, and so that opposition will stand as an opposition to the third renewed motion. I don't know the exact title, Mr. Gibbs, but we'll proceed today. We want to proceed to a decision.
Yeah, we already closed those motions, Judge. Absolutely.
Yes, I saw that there. Okay.
So I just wanted to say, we received a notice that today's proceeding was about the status check as well as the motion to compel. Are you saying that you want to hear argued on all three of the motions or just that issue?
All of it. All of it. Try to write it all up in one hearing. You are set for trial. When are you set for trial? Early 2021.
Yeah, March or something, I think, Your Honor?
Yeah, we had a status check. Mr. Grimes is on the other side, is that correct?
Yes.
Was Mr. Grimes noticed of this motion?
Yes, we noticed him of the motion, and I think the court gave the notice of the actual hearing date.
Mr. Grimes got it too?
Yes.
I don't know, Judge. I have no idea because we weren't noticed of the motion to that effect. We were told it was a status on the first thing and not on the others.
Let me check on the notice issue to Mr. Grimes, make sure we're okay with that. Let's see. My JEA should have sent the blue jeans to everybody.
And I can't tell from mine.
Okay, I could go into the blue jeans app. So give me a second, look into your meeting and find out who the participants were. I might be able to participant list.
Who has it?
Okay, me, Lozano, Grimes, and Gibbs. All right, so Melvin got a copy. Court notes, Melvin Grimes received notice of the... But did you serve everything 3 ways?
I don't think we served the notice of the hearing order because it came from the court. We served everyone with all of the pleadings that we filed in this matter.
That includes Mr. Grimes. So yeah, that's standard practice. Okay.
Correct.
You too, right, Ms. Lozano? And Mr. Grimes, every time you file a pleading, you copy Mr. Grimes, Attorney Grimes.
Absolutely, Judge.
Received notice of the blue jeans sent for today's hearing and has not appeared today. And he, counsel represented, they served him with all pleadings and to date. I just want to note that, and so I'll just note his, for whatever reason, as between this dispute between the plaintiff and her former counsel. Okay. I'm sorry. Go ahead, Mr. Gibbs. Proceed.
If Ms. Lozano objects to proceeding on all these issues today, I have no problem until 13th. But if we're going to proceed today, everyone's briefed on it, I'll proceed. So as to the motion to compel, I think there are basically 2 main questions for the court to consider. The first question is, setting aside their name for a moment, if there wasn't an attorney's name on the file, would a subpoena ducis tecum for Ms. Lozano's case file be something that we should be able to seek in discovery in preparation for the evidentiary hearing to adjudicate the attorney's fees? Because if you don't think that with or without a lien, this is something that we would be allowed to discover on the issue of whether or not the attorney's fees are appropriate, then you don't really get to the second question of the lien because you would have granted anyway. Our answer is obviously yes, for reasons I'll elaborate on in a moment. Can you hear me now?
I am, and and I'm just typing notes to myself in the chat box just to help my court clerk. I'm absolutely listening.
Okay, I just never sure how good my equipment is. And then the second question is, does the fact that there's an attorney's lien filed in this case mean that the file is not subject to a subpoena juris tecum? And our answer is, no, you can still do a subpoena anyway because we have an evidentiary hearing and we're allowed to prepare for it. So let me just elaborate briefly on question one. So I think it's common sense and fairly obvious that everything Ms. Lozano did for Luba Gonzalez, every letter she wrote, every motion she prepared, every discovery request she made, and every phone call she made and made notes on, all of those things are things which, to the extent that they appear on the bill, they're all relevant to the question of did Ms. Lozano perform the legal work that is showing up in the bill, and is the charge for it appropriate? Ms. Lozano says we should just go to look at the bill and say, hey, those questions seem, those particular charges look suspect to us, and that's all we need to know. And the court will recall that Ms. Lozano didn't even attach copies of her billing statements to her initial motion to reduce those to judgment. She did it, I believe, with a reply. So I would disagree with you. I think that, for example, if Ms. Lozano billed hypothetically a charge for sending out a letter to opposing counsel on October 10th, and there's no letter of October 10th to opposing counsel in her file, then the charge is erroneous and perhaps mistakenly billed to the wrong file. If there's a letter dated November 6th, hypothetically, and the charge is for 1 hour, but we look at the letter and it's 6 sentences long, then the 1 hour charge might not be reasonable. So, in defending Luba Gonzalez, I have a right to see the product that she's being billed for. It's as relevant under Rule 26 as can be to the issue of are these legitimate charges and what work is appropriate. So unless you find that there's a procedural bar to this subpoena, I believe that you should find that Ms. Lozano should have to provide her file based on it being relevant to the question before the court in this evidentiary hearing, which is whether or not these charges are reasonable. Now, what Ms. Lozano said initially, yes, the court did order that we are to provide a list of the document, the particular charges that we dispute, but the discovery is toward that end. That's one of the last things that's supposed to happen. We did our due diligence to gather information to find out what charges appear to be legitimate and what ones do not. I would suggest to the court that if we did what Ms. Lozano suggests, just look at the bill and just make a blanket objection to particular charges without this information, it would be irresponsible. I think we're entitled to information, and if I get this file and I think a charge is legitimate, I'm going to tell Luba Gonzalez I think this is appropriate for the work performed. So absolutely, I think we're entitled to it. And then we have to address the second question, which is the legal one. Does an attorney's lien mean that the attorney's file is not subject to a subpoena? Well, first of all, Rule 26 does not indicate that the documents in an attorney's file are not subject to discovery when there's a lien. It doesn't say that at all. The scope of an attorney's retainer lien under NRS 18.015 is set forth there, and it's somewhat narrower than I think what Ms. Lozano is promulgating. It says that the lien attaches upon any file or other property left in the possession of the attorney by the client. It also says that it also attaches to copies if the attorney has retained the originals to the client. So let me just throw out a hypothetical for you to consider. What if instead of an action before this court to reduce this lien to judgment, there was a bar complaint filed against Ms. Lozano by Luba, and the state bar wanted to get copies of her file to investigate and prosecute our complaint, just hypothetically. So,
It was not a bar complaint, it was a legal dispute, let's be clear.
Yeah,
I'm not
that's
telling you
right.
it's a dispute, I'm just saying it's hypothetical.
I'm just saying it was not a bar complaint, it was a fee dispute, Nathan, let's be clear.
I'm saying hypothetically, okay? Let's say that instead of fighting about this attorney's fees, somebody files a bar complaint and the state bar says, we want to act on this and investigate it, we're going to issue a subpoena to Ms. Lozano for her case files. Would Ms. Lozano have to turn over her files in that circumstance, Your Honor, because the state bar subpoenaed them? I don't think anyone would say that Ms. Lozano could just say, I'm not producing those, I have a lien on them and I'm not giving them to you. And yet that is kind of what she's doing here with respect to the subpoena that I issued. You can't do this because I have a lien. A lien does not say that you cannot subpoena the information or documents. It just means that Ms. Lozano does not have to give them back to the client. I'm an attorney. I have a right to subpoena records to prepare my case for this client. If you want to tell me I can't give them copies to Luba, well then so be it. But there's nothing in the rules to suggest that by virtue of having a lien, you cannot conduct discovery and properly prepare for court. I would note that, and that this is a fairly obvious point, that a retainer lien is different than a charging lien. Both of them are set forth in NOS 18.015. The charging lien gives the attorney the immediate right to intercept money that's owed to that attorney's former client right away. Just basically give it to me instead of the client. But on the other hand, a retainer lien doesn't allow you to get any money out of anybody. It's just a piece of paper some paper on your shelf in your computers, unless you have a motion to reduce it to judgment and you seek a money judgment. So in a sense, and particularly the new rule applies to copies as well, it's a sort of a symbolic kind of a lien, which is nothing more than something incident really for getting a money judgment. So the bottom line here is the court needs to weigh, not only consider the lack of any law that says that a document seller and a retainer lien cannot be subpoenaed. I've not come across any law that says that or statute. But if you weigh the harm to Ms. Lozano, she can continue to have a valid lien by retaining copies or originals and giving copies to me to prepare for trial. On the other hand, Luba, without this information, is handicapped in being able to fully investigate the work that was performed and be able to try to discern which charges are appropriate, or if something looks like it ought not to have taken 7 hours or 2 hours or whatever the thing is, then she ought to be able to look into that. And finally, I would note, Your Honor, that we have a rule of civil procedure, NRCP 45A4, 4B, which says what a person is supposed to do if they get a subpoena and they don't like it. They don't think they should have to respond. It says they have 7 days after being served with a notice and the subpoena to file an objection to it. This was not done. So several months ago, had Ms. Lozano's position been that she did not legally have to comply with the subpoena, NRCP 45A4B says what you're supposed to do, and she didn't do it. So our position is that the court should order Ms. Lozano to produce a copy of the entire file and then reset the scheduling of this hearing with sufficient time for us to review it and to produce a final list of charges that we dispute. Now, I want to address briefly, there's counter motions for sanctions, and I didn't know we were going to proceed on all of the motions today, but I want to separate the request for sanctions on this motion to compel versus the other motions. This motion for sanctions alleges that it's improper to send these subpoenas for documents relating to the subject matter of the evidentiary hearing. I think for the reasons I've stated, I don't see clear law that says that it's objectionable to do so. But this Ms. Lozano further claims that I filed repetitive motions, and I want to be really clear, this is the only motion that I have filed asking to compel production of these documents. In prior motions that I filed motions to continue, and I didn't ask the court to order Ms. Lozano to produce the documents per se before this. I previously just said, take the matter off calendar until she decides she's going to comply with this, and left the ball in her court. So this is the one and only motion that I filed. It's not a repetitive motion on the issue of specifically order her to produce the documents which were subpoenaed. Now, as to the second motion, the motion to continue, I have an email from the JE of the department indicating that we're not going forward today. We're going to have the status check, and this matter is going to be set. So I don't know that I need to really belabor that. It sounds like the court is going to set it in the ordinary course or as soon as possible once you deal with the other issues. But the third issue is our 60B motion, Your Honor. And basically I wanted to advise the court. The court's ruling in this case is a somewhat unusual one back in February. And we've cited in our brief, which you've indicated you looked at very carefully, that we gave the exact citation where you said, I'm going to set this for an evidentiary hearing in front of myself, and I'm also going to allow the state bar to go forward with it. And whichever one basically gets it first is going to have the right to do it. So that's what was actually said, and we told you the exact citation where we said that. Ms. Lozano, in her opposition, has quoted something you said, suggesting, well, they're probably not going to get to it before me, and is taking that to mean that you changed your ruling on the matter. Well, I don't think you did. I don't think that sounds like a ruling. It sounds like you simply were saying, well, I think I'm probably going to hear it first, but you didn't say, and never mind, I decided that the bar can't hear it. So your ruling was that Liberty could go have the fee dispute be heard by the bar or by you, sort of whichever gets it first. However, notwithstanding that, I'm sorry?
I think that's accurate. I was proceeding, and the state bar can do as they wish, and if they wanted to proceed first or they wanted to wait for a ruling from me, and somebody cited in their exhibits the governing policies of the State Bar Fee Dispute Committee, and it looks like if they see an actual litigation in the district court case, they will not proceed, apparently, according to their rules.
Well, let me address that.
Okay, we'll weigh in on that. Go ahead, Mr. Gibbs.
If you read I can pull those up, but I think that's sort of missing a subtlety. The rules allow that the state bar, if there's an action in front of the district court, and the district court allows them to proceed, then they do. So it really depends on what you do. There are cases when someone proceeds on a lien, and the state bar proceeds because the judge says let them handle it. It's not necessarily that the first one to go governs it here. So if you look at the rules carefully, and I can look at them while Ms. Lozano is making an argument, but I believe that it allows for just the thing that you did. But the problem here is really that Ms. Lozano prepared an order. She didn't run it by me first. She submitted it to the court, and that order omits the second half of that equation that says the state bar can go, or I can do it. And then she presented that to the state bar and said, look, see, the court took jurisdiction, you don't have it. And based on the fact that the court did not, that part of the order was missing, Ms. Gonzalez was deprived of that form which you intended to allow her to have. And so the reason for the 60B motion is we would like that corrected. And it may be moved if you're going to have this trial in a month anyway, it doesn't matter now. But if it's going to be in 6 months, the state bar should be able to proceed if they get to it quicker, and that's what you ordered. And nobody can dispute, and you haven't disputed that that's what was ordered. address the counter motion on those for sanctions. I did file multiple motions, simply because no ruling at all was made on these. And I'm not trying to be a smart aleck. The procedural history of this in both May and also subsequently was that the court made some rulings and advanced the hearing date. You moved it out, but you didn't address the issue of the 60B in either of the first two settings, and they were calendared to be heard. And I assume it was just an oversight, but I don't think there's anything improper about renoticing a motion that hasn't been ruled on. There's a rule that says you can't just keep asking for the same relief over and over and over because you don't like it. That's not what I did here. I said, I guess something got lost or along the way, and I'd like a ruling on this. Whatever way you rule is how you rule. That's the way it works in court. The other thing that Ms. Lozano says is a reason for sanctions, besides repetitive filing, is that I didn't check in with her first adequately to see whether I could work it out first. Well, I didn't do that before I filed my first motion, but Ms. Lozano didn't respond to the first motion by saying, oh, you know what, Mr. Gibbs, you're right. Let me change this. My bad. I filed the second motion, which she opposed in writing any changes, and then she filed the second opposition to this. I don't think we can infer from this that Ms. Lozano is fine with changing the order and granting the 60B motion. She did point out a very interesting technicality, which I think she's right on the language about, Your Honor. I will concede that the Rule 60B itself allows relief from a final order. I would argue as to the state bar fee dispute, this is a final order because it cut them out of the mix. But I think technically as to court procedure, it was an interim order, and the final order is going to be the judgment that you enter at the evidentiary hearing of this matter. But the court also, Rule 60A also allows the court to correct any mistake in the record at any time. So, irrespective of whether we want to call this a final order or temporary order, you have a right to correct it if it's just plain incorrect and not what you ordered, which is what the case is here. So we would ask that the order be corrected along the lines of what we asked for, and we'd be allowed to do our discovery, and then prepare and have the hearing. That the soonest time you can do that on your schedule after those things can be completed. Do you have any questions on my position, Your Honor, or would you like to
Yeah, what's the date of that order you're referring to?
I don't have it in front of me because I didn't know we were going to do that today. I think it was in March. Late March. Does that sound right, Ms. Lozano? It was from the February 19th hearing, but it was about a month later.
It's from the February 19th hearing, Judge. I don't know the date.
Oh, there it is. File date is March 17th at
That sounds
2:40 p.m.
Yes, that sounds right.
That order is filed 3/17/2020 at 2:44 p.m. All right, I have that order in front of me.
Yeah.
Do you have any specific page number or line number? You don't have it in front of you.
I can get it.
The court finds that the rule under law is don't let the state bar hold a judge back on ruling on attorney's liens. That the motion to withdraw is granted, substitution was accepted. There are no Argentina issues. Yeah, I think that part's correct, that the motion reduced attorney's lien with Ren, however, it's not. Yes. We'll set it for evidentiary, yes. And so I think your request to the court today is to language page 2 of 3, lines 7 through 9. The court finds the rule under law is don't let the state bar of Nevada hold a judge back on ruling on an attorney's lien. So if you are asking to have a little amendment, revision, what is your proposed amendment or revision?
Course of Justice for just another one, okay? I'm going to pull it up on my computer if that's all right.
Absolutely. Okay. It's page 2 of 3, line 7 through
Your
9.
Honor, that was a finding, not an order. And Your Honor, for the record, Section 3C1 of the State Bar of Nevada Fee Dispute Arbitration Rules clearly state that the committee does not have jurisdiction over disputes regarding a complaint and or motion to determine the fee that has been previously filed, not adjudicated, filed with the court of this competent jurisdiction unless issue of fees is requested by the court to be handled by the fee dispute committee.
Right.
So he's going to say that you have it, but they already started that. It was already done.
I reviewed that exhibit. You submitted that rule and regulation. I will be candid and tell you at the time of the February hearing, I do not memorize every rule and regulation and policy of the State Bar Fee Dispute Committee. So, kind of after the fact, Ms. Lozano pulls that rule and regulation, and if that is that rule and regulation their own specific policy, or is that something that is binding?
I did reference it at the hearing because I did say if there's a matter that's before the district court, and I did not have the reference because I don't know them memorized.
I see.
But I said if there is an issue in front of the district court, they have jurisdiction. If the state bar has it and then something's filed, then the state bar has it. I said you had jurisdiction because of this. I did not know the rule. I filed it in after we did the opposition, Judge. I did not say it in February. I referenced the idea, Judge.
How does that impact in any way on your client? Is she, Mr. Gibbs, what's the point of that? Is she wanting to have the option to go to state bar?
Yes. Yes, and if, for example, takes you, and I would argue that even under the way the rule is written, you do allow for the state bar to handle it. That's kind of the point here. So she would like, if you end up, like I said, if you end up hearing this in a month or two, probably they're not going to get in front of the state bar. For an amount this big, it's going to be a panel, which is going to take more time as opposed to an individual person that hears it. So, but if it's going to be 6 or 8 months, it may get resolved by that, and it's a forum that you allowed for her to have, and I think she's entitled to the benefit of your learning. So, we're just simply asking that basically that what you ordered, that the matter can go before the state bar, and if they hear it before you allow them to do that. That's basically what you ordered, and it's consistent with the rules.
And Your Honor, obviously this is saying that's not what you ruled, because that is what we ordered. I did argue back in February, according to the state bar, just because this is my notes from them, the Dispute Arbitration Committee rules, as amended November 8, 2019 and 2017, regarding jurisdiction, the committee does not have jurisdiction over the following matters. I read the quote that I put in my opposition: disputes regarding which a complaint and or motion to determine the fee has been previously filed with the court of competent jurisdiction unless the issue of fees is requested by that court to be handled by the fee dispute committee. He keeps trying to flip the argument and saying that you wanted it. I told you at the time, I said,
We're not bound by their policies.
Absolutely, and I understand that, Your Honor, but I want to go back to his original arguments on everything. And yeah, there is relevance to LUBA on what's going on, but the retainer agreement you have in front of you shows that she reviewed everything and got copies of everything. And also that she had 30 days to even tell me if there's anything wrong with it, which she did not do. And then also the rules are very clear, and Nathan quoted this earlier, that an attorney does not have to give them to the client. But he's saying, let's do a subpoena to the lawyer of the client, which is exactly what the law says do not do. Out of the attorney's mouth today, he said exactly that, and that's exactly what the rule says. The rule says do not do that because the only thing you can do in this, there is no money, there's nothing else. The only thing the retaining agreement allows us to do is to be attached to the documents in the file, including copies contained in the file. Okay, so that's all there is, Judge. So when we're talking about what we're going to do, we can get this over with right now. He's already said, these are the problems I have charges with. I already said, no problem, get rid of those charges. I said that before the prior hearing when I agreed to reduce it by $5,000, I believe it at that time. Again, he already said it, let's just drag this out, Judge. 6 to 8 more months? Really? She hasn't paid me for a year already, Judge.
I didn't say that. I said whatever it said.
She has the money. She can take care of this. I am being forced to continue all of these proceedings at want zero money in a tiny little law firm, and he knows just drag it out as long as we can, and she will never pay her. That's exactly where it is. And when you say that we can't tell from the bill, Judge, you know how long we were in trial. Those are right on the bill. How long it took to do a motion? It's right on the bill. How long to do a motion? Nothing's unusual. The things that were
by like $10,000 difference.
I'm sorry?
So, are you guys off by about a $10,000 difference? Because Nathan's arguing.
No, he has a zero number. He says he wants to give us zero money, Judge. That's what I think is ridiculous.
I don't think he said that.
No, I'm not saying that.
I think
That's exactly what he said, and if you need a copy, Judge, I will show it to you. He says zero.
the very first thing I wrote in the chat box here was this $42.65.90, no objection to deduct from the bill. What's your final number today?
Yeah, Judge, because that's the numbers that they pointed out for the motion. I agree with you, Judge, because you said anything to reduce it to attorney's liens, let's get rid of it. So before, that's why I said 5,000 off, and then we were actually a little bit more because we went to 14. Where's my number? I'm sorry, Judge. Hang on one second. My
Take
number.
your time, come up with that number, and I'm going to
It's 4,000. Hang on, Judge.
Take your time. Take your time. I want to know where you stand in terms of if you got that amount of money reduced to judgment. Now, what's going to happen with her client file?
I'm sorry, Judge. Here we go. Okay, yeah, $4,265.90 were the issues that he had with the file. I said, no problem. So, and then it would be $14,124.60.
Got it. And, okay. Now, anything else further in your legal argument on why you believe the retaining lien gives you the power to hold the file and that they're not entitled to the file for purposes of this fee dispute evidentiary hearing?
The two reasons I just gave you, Judge, the retaining lien statute, the actual
Okay, so
statute.
if you look above in my chat box, I do note that you already submitted and filed on January 29th, 2020, your billing statements, redacted billing statements. Do they need to be updated in any regard, or you stand by what you produced on January 29th?
That was it, Judge, besides all this time we're spending on the fee dispute. That's it.
That'll be additional time. Okay. All right. Anything on the bottom, Mr. Gibson, I'll be prepared to go.
Yes, Your Honor, I just want to correct what Ms. Lozano was saying with respect to my position. Because I didn't yet have a ruling on this, I sent her a list of objections within 30 days of this setting, and in that objection, I gave a blanket objection to all of the bills until I got this issue of the subpoena resolved, and then I also enumerated certain specifics that I was already aware of. Ms. Lozano is trying to pass that off as if that's the only things I had an issue with, and that's a mischaracterization of my position. So she's argued that and also argued that I said that zero was what was owed, both of which are wrong. Here's my position. I have certain things that we've already questioned, and I told her those things, and I also want to see the file so we can make a determination based on evidence of what other things seem inappropriate. That's my position, and I think we're entitled to it.
Anything else, Ms. Lozano? And then,
Again, Your Honor, that's disingenuous to try to get around the statute. Okay, Your Honor. And he knows exactly what's in it because she's been provided with copies of everything. So it's not like she doesn't have a copy of a document. And then the only other things besides documents is time in court. And that's very clearly shown by the record like we have today, Judge, on the time that we went over there, 3 minutes in court, and then left. So it's not a very unusual file like we had a ton of depositions or experts or things like that. It's very clear. It's just documents and time in court. So when he's trying to say that we need some mysterious number here, he can tell the motion is drafted in a couple hours. We know in the state bar that's what they're going to require as well. you as a judge would know because you've been on the bench for 20 years what it would be to draft a motion and to argue that motion. So it's not a very unusual thing. What he's trying to do is get around it so she doesn't have to pay for the retaining lien for the pick up her property, her statute, that is required by statute to be kept until she pays for it. She wants to get something for nothing. And you, a million times I've heard in your courtroom, I'm not required to allow lawyers to stay on cases and do the work for free unless they're doing it for pro bono. And again, on this one, it was really clear that she just didn't want to take care of this. And it's very clear because even though Mr. Gibbs says he doesn't represent her on the fee dispute, he's done a ton of work on this, Judge.
You get the last say, Mr. Gibbs.
And Freedom-Nellie is really, really, really clear, Judge. I want to make sure it's very, very clear under Freedom-Nellie that 8015 unambiguously permits an attorney to continue, Judge.
I'll just say, as to the 60B motion, on page 12 and 13 of our motion, we've listed all the things that were incorrect in the motion, and we'd like those made. As to this issue, my client simply wants to be able to compare what is in Ms. Lozano's file to what the bill is, and if she agrees with it, then we're not being hearing. We just want to know. We have a right to defend her.
And, Your Honor, that's disingenuous because she's gotten everything. Now hasn't disputed one thing, although it was required in her retainer to do it. She has still not disputed one charge.
And that's an argument to be made at the evidentiary hearing about the effect of that.
Okay. Final judgment needs to be adjudicated. All right. There's a little long paragraph in the chat box there. I'll read it. NRS 18015 grants an attorney a lien if they meet all requirements of the statute. I think it's a 4-step process, giving notice, certified mail, etc. I don't think there's an issue with that. The Argentina case discusses the court's jurisdiction to hear a lien. Attorneys have since updated their retainer agreements to discuss the court's jurisdiction by providing for client consent to jurisdiction if they have an outstanding balance due or they don't maintain the retainer amount on account. Now, retainer is absolutely proper in Nevada. See the Freedom-Nellie case. If NRS 18015 requirements are met, they're met. Here, there's just a dispute as to the reasonableness of the fees. The final judgment amount needs to be adjudicated. Okay? So here's what happens. My analysis of this statute, the Argentina case, Leventhal, Freedom-Nellie, and I think there was a New York federal case. It was a criminal case, but it discusses also the court's jurisdiction to hear. I think I'm assuming. Did you produce your retainer agreement as well?
Yes, Your Honor. Yes, Your Honor.
Okay, very good. So I'm assuming, and I asked you at the February hearing, Ms. Lozano, did you update the language of your retainer agreement to kind of get around Argentina to give the court jurisdiction by saying the
and you acknowledged it at the hearing, Judge, on the record. I appreciated that. Yeah, that's correct. Yes. Yeah, I appreciate it.
So that, and I don't know if you referred back to that part of the order. It's just a finding by the court, and the court sua sponte at any time, even if it's temporary findings and temporary orders, can amend the language of that line 7 through 9 on page 2, but I don't think it, I read the entire rest of the order and it looked proper to me. I wouldn't make any changes to it other than that page 2, line 7 and 9. It's just a finding though, Mr. Gibbs. Now whether that finding and supposed to a court order will impact what you're going to tell the State Bar Fee Dispute Committee. First of all, I'm not bound by their regulations and policies. If there was a motion before me, I'll rule on it. Now, if there is a State Bar policy itself saying we're not going to act if there was an active motion or complaint before the district court, then they're going to go down that route. And by clarifying that, instead of I would grant your motion 60B to amend that language to cite to the actual regulation under this, and it's right. The court acknowledges this. I acknowledge this regulation or policy of the State Bar Fee Dispute Committee, that it doesn't really impact on my going forward. If the State Bar Fee Committee now sees that there's something active in the district court, a trial is set, it is their policy not to proceed. And so there's no other end around one can do, or there's no other way to convince them to go forward with their fee dispute. Now, as far as the trial, we kept talking about it a couple times. You know, let's wait for Ms. Lozano's trial after we finish the divorce custody trial. And that's something, you know, we could take a look again if you want to go to a trial on attorney's fees. Maybe we could do it by blue jeans because there's not going to be a lot of...
I'd like to resolve it, Judge, if we can.
The solution, the answer, the legal answer, and I'm going to write it in the chat boxes here. From case law, from Nevada case law, it is apparent. Now, hang on. I don't know if I highlighted it in the Argentina case, but I clearly remember. I don't know if it was in 3-9. But putting it in simple terms, from Nevada case law, it is apparent that a client may get their file turned over if they put up some type of collateral or security for the disputed amount, or pay up on the bill. Pay off the bill. So either Ms. Lozano is retaining a lien. The purpose of it is to have a lien on the file. The file must be turned over if you put up some collateral to cover that amount, or to pay off the bill. Since she's not going to pay off the bill and wants to dispute with some of the reasonableness of the charges, okay, there's in the chat box there. Then you do it two ways: pay it off, which she's not going to do, or well, there's a third way. The third way is to settle out of court, basically, and agree to some agreeable amount. You know, the other way is to put up some kind of security or collateral. If I do the security or the collateral route, okay, and you have the trial later on, okay, at least she still has her judgment that she can hang on to. If she does security or collateral route, I just don't know if she can execute, unless the court says maybe up to a certain amount, you can execute on the judgment by writ of execution. Okay, so what her goal is, the Attorney Lozano wants to get that judgment, and if she gets that order, if the judgment is signed off by the judge, then she could turn the file over, okay, because then she has the requested amount that she requested. If you put up some type of security or collateral, I just don't know. There's nothing you can execute on until the final resolution of the case. There are some tricky case law about asking for this kind of stuff after a case is over, and I think that might be tricky about the court losing jurisdiction because they're advising and they try to give some guidance. You're going to do a lien, you better do it before the final adjudication of the other issues on the case. But neither here nor there, she's properly filed before this case is finally adjudicated on divorce, custody, property debts, alimony, etc. So there's your answer. I think you need to either put up security or collateral until we have that trial, and then I'll have her turn over the file because she's guaranteed money either way. Pay off the bill, or sign you can sign a confession or judgment. But it's either way. There's got to be something that will, obviously, that's what an attorney wants, to protect their interest in making sure they get paid for the work that they did. Okay, so how do we proceed? Well, first of all, Mr. Grimes is not here. I couldn't get him to look at his calendar and find out, so the JA will have to set. I can't do it without Mr. Grimes here, so JA shall contact both Gibbs and Grimes for the trial dates. Okay, I don't know how much you'll request and for how many days. Starting many days. Day four is up next, right?
Wait, that's what I said.
I don't see it in Odyssey.
Oh.
March of 2021. You said that it was March of 2021 when you started the proceedings, Your Honor.
I'll think about the findings for the order setting. Yeah, I'm pretty sure.
I think that's what Mr. Gibbs said, or you said at the beginning of this, that the trial is next year.
Second amended order.
There we go.
Okay. You know, there was a little tricky question about when discovery closed as well. It's, no, the last one I see is September 15th. I don't see anything else. Maybe it's in an order.
Well, I know we got an order, but I don't know if we got it in writing on it, but we did get a date when we had the status check in August or July.
Oddly enough, I don't see it in Odyssey. But I'm sure it's there, but I'll check. No, I don't see it. All right, and I'll ask Susanna about that. Helen, if you're listening, can you ask Susanna if, in the Luba Gonzalez case, if there's the trial dates have been set? Because I don't see it on Odyssey.
Yes,
If I don't see it on Odyssey, and if it hasn't been set, I'll just have Susanna call both the attorneys, Gibbs and Grimes, to arrange the dates that's fits their schedules and their client schedules.
Okay.
Okay. So now, as far as this motion, if there was, I know there was an order saying
Your Honor, we got Mr. Grimes on the phone. Would you want him to call your office?
can you just get on the Blue Jeans link?
I don't know, can you just ask him to get on the Blue Jeans link?
Melvin?
You want a link to this hearing?
Hold on 1 second.
Hang on, it's Christine, it's his secretary.
Tell him to jump on the Blue Jeans.
He just needs to jump on the Blue Jeans thing.
Okay, let me mute my audio while I call my secretary and find out what's going on.
Hi, this is Kathy at Don Lozano's office. On the Gonzalez matter, the judge is asking if you dates.
Great, thank you so much. He'll jump right on.
Your Honor, he says he's going to come right on.
Hey, Susanna, I'm on the record here with Gonzalez. Did you set trial in this case? I don't see it in Odyssey, or am I looking in a different case number? I think it wasn't set because we were supposed to go to trial today, but it's converted to a status check so I can give out the trial dates, correct? That's what it was. Okay. So Mr. Grimes wasn't appearing earlier. He's jumping on Blue Jeans now, so I'll assign those dates, and you're doing amended order setting evidentiary hearing for the day 4 of trial. All right, thank you. Okay.
Thank you.
All right. I think what you guys heard was just me talking about March back then. Now we're up to April or May. So we better grab these dates, and it's good if Melvin can get on the Blue Jeans. We'll wait for him to jump on. And I can arrange those trial dates. It may or may not have something to do with Ms. Lozano, because the idea was to do her evidentiary hearing on her attorney's fees after we finish your trial on divorce and custody, but I can entertain the argument again. What does this timing matter?
Your Honor, like we said from the beginning, I don't know why it matters. There's nothing that it matters to.
Yeah, I'm giving that to
It's the award of attorney's fees has already happened. It's just a matter of...
Yeah, I'm not doing in-person trials, and I think I asked both sides, and they want an in-person trial, and it's not going to happen through the end of the year and then I retire at the end of the year. But if this is something you guys want to do on Blue Jeans and all the exhibits, because the motion to compel is pursuant to the law is denied, the retaining lien is absolutely proper, the solution is to put up a collateral or a bond, or pay off the bill, and then we can have that trial on the reasonableness of the fees. And that's only if you want the whole file.
And Your Honor, I would submit it on the pleadings, and you could rule however you want. So I'm not even asking for any time in front of the court.
You waive your right to an evidentiary hearing and have
I've submitted on pleadings, absolutely. If you'd like, we could show what he has and what we have, and you could submit it on the pleadings to save everybody time.
I'll have to take a stipulation from both sides. If Luba wants to testify and go over the line items, I could make sure that discovery is answered on the redacted billing statements of every line item.
And then we can submit our answer.
All right, so let me write this in the chat box while we're waiting for Mr. Grimes. So court orders that Attorney Gibbs' motion to compel is denied to the extent that the retainer lien on the client file is proper, okay? Mom would have to put up collateral or pay the balance off to get her client file. Okay. Right, that's the only option. Or so court. Now, as far as discovery, the other discovery, the Attorney Lozano has already produced her retainer agreement, which is proper. She can a supplemental billing statement for the additional proceedings up through today. Okay.
Your Honor. I have it when I can.
And as far as line, Attorney Lozano requested line items disputed, and Attorney Gibbs, you should answer that discovery. What line items are you disputing? Should,
Well, like I said, it's hard for us to do without seeing the documents that back up, and that's what
you work with what you have. Yes, you work with what you have.
Well, I would respond to the best, if that's your ruling, to the best of my ability.
Okay,
And
and
respond and ask for a ruling of the judge. We wouldn't ask for anything more than that, Judge, because you're familiar with the case.
Attorney Gibbs, I don't know if you had a chance to talk to Luba about that. Did she waive her right to an evidentiary wherein you file your line item responses, formally file it, even though it's a discovery response, you'll file your line item disputes because it's going to be your brief if you want to waive an evidentiary hearing, and then Ms. Lozano gets an opportunity to respond to the line item disputes, and if Mom is the moving party, she gets a final rebuttal onto that response, and it's under advisement. Now you have to get a stipulation you want to waive the evidentiary hearing on that.
I'll agree to it.
She does not want to waive it, Your Honor. She would like to have an opportunity to cross-examine and have you judge.
Well, it should be done. I can't see it going more than a half a day. If I can squeeze you in half a day, we can do it on Blue Jeans.
I think it's appropriate for Blue Jeans for this. It's a different scenario than the trial itself, which has a lot of videos and whatnot. So we would be fine with Blue Jeans on this.
Yeah. Okay. Let me write this. Attorney Lozano. Good afternoon, Mr. Grimes. Are you reading the chat box? It's been what we've been talking about since the first minute. The first thing I asked is Mr. Grimes properly notice of the hearing. We got the Blue Jeans link, and suddenly Ms. Lozano said your assistant was calling her office.
No, we told Mr. Grimes' office, and Carol patched him through, Judge.
Oh, gotcha. Well, yeah, Mr. Grimes, you got properly noticed the hearing. We were not going to dispute whether or not you wanted to attend this hearing. I would tell you, I summarized this past hour on that chat box there, so it doesn't really impact your client or you. But this is kind of where we're heading. And I'm glad you got on because I want to set the trial dates with your calendar, if your assistant's there with your calendar, because you haven't been locked in. Today was supposed to be the trial. It was September. We thought we'd be back in the courtroom, but due to mask requirement, a lot of limitations, we already talked about that. We would reset you, but today was the day we're going to give you your trial dates, and we're going to give you those dates with the explanation that you're going to get a new judge either way, whether in the State Department I or one of the brand new judges. I doubt you'll go to another current judge, but with a brand new judge, unless you file a peremptory challenge. And then, if it's a new judge, they rearrange their own calendar the way they want it. So little hint to all you attorneys, you might want to call end of December and bug that department and say, are we a firm date, or are we going to rearrange it somewhere in that vicinity of that calendar? Because we want to know when we're going to be ready for trial on the day 4 of the divorce trial. Okay. Do I have a stipulation to do